And awfully pleased to have with us on the phone Mr. David Thompson, attorney with Cooper and Kirk. David, good evening, sir.
Good evening, Cam. Good to be with you.
It's good to have you with us once again. Thanks very much for your time tonight. The Brady campaign, which is, I think, continuing its slide into irrelevancy and is trying to fight back by being as outrageous as it possibly can be, had a blog post the other day, the NRA's courtroom craziness, and they apparently are really freaked out, David, over a couple of lawsuits filed by the NRA in Lubbock, Texas. They say one seeks to strike down a federal law barring licensed gun dealers from selling handguns to persons under 21 years of age. The other suit challenges a Texas state law generally barring persons under the age of 21 from carrying concealed weapons. In these cases, the NRA seeks to establish a constitutional right of persons between the ages of 18 and 20 to buy handguns and, they say, to carry them concealed in public places. This is
exactly right. You know, Cam, they're really arguing. They're trying to make 18, 19, and 20-year-olds second-class citizens in this country. And their basic theory, in a nutshell, is that the allegedly higher incidence of gun violence in this age cohort justifies this second-class treatment. And this argument is flawed at every level. And if you'd like, I'd be happy to walk you through why that's so.
You bet. I would love to hear it, David. I mean, last night on this program, we were talking about the sort of, adolescent culture in this country, and I believe, the detrimental effects that it has had, but that certainly doesn't mean that every 18-year-old is an irresponsible idiot who can't be trusted to exercise his constitutional rights. So, yeah, I'd love to hear it.
Yeah, well, let's start with the fact that the Brady Center seems to have forgotten that there was a decision called Heller that was decided by the United States Supreme Court, because Heller was crystal clear. It mandated a historical inquiry into the scope of the Second Amendment. And the history is overwhelming that people in this age cohort, 18, 19, and 20-year-olds, were covered by the Second Amendment. The Militia Act of 1792 covered 17-year-olds and up. Fathers were required to train their children in the use of firearms, and the young adults. All states allowed 18, 19, and 20-year-olds to keep and carry guns at the time of the founding. So the history is a slam dunk on this, and that's really the end of the matter. But the other thing that's interesting is if we look and we say, well, is there something odd, or idiosyncratic about this result in terms of the Bill of Rights? Whether you're talking about the First Amendment, free speech, the Fourth Amendment, right to be free of unreasonable searches, Fifth Amendment, right to be free from self-incrimination, Sixth, right to confront your accuser, Seventh, right to jury trial, or the Eighth, right to be free of cruel and unusual punishment. Every other provision of the Bill of Rights fully covers and protects 18, 19, and 20-year-olds. So how can it be that, this one provision of the Bill of Rights is different? It's not different. And constitutional law isn't the only area of law that says this. In criminal law, if you're 20 years old and you commit a murder, you're not going to juvenile court. And the same is true in family law. When you're 18, you're treated as an adult. So, this argument is totally legally foreclosed. Now, the one thing they love to say is, yes, but what about voting? They say up until 1971 and the ratification of the 26th Amendment, the voting age was 18. And they're right about that. But, there are two key distinctions from gun rights. First of all, voting rights aren't in the Bill of Rights. And second of all, the history supported that limitation. In other words, at the time of the founding, you had to be 21 to vote. But you didn't have to be 21 to have a gun. So, that argument just flat out doesn't fly.
Yeah, go ahead.
Yeah, and now what they're really left with is arguing basically Justice Breyer's dissenting position in Heller. And, this could be relevant if Obama gets a second term and is able to put in another, anti-gun justice on the court, then we may be in this terrible world of interest balancing where, you look at, well, is this good public policy or not? And even if we were doing that, there are at least a couple of reasons why the Brady Center would be wrong again. First of all, their theory is that 18, 19, and 20-year-olds, they're not fully mature. They make some bad decisions. Well, we allow these young adults to engage in all sorts of activity that is dangerous. They can fight in a war, after all, number one. Number two, we allow them to drive cars. And, more people die in car accidents than from gunshots. And we're allowing people 18 and much younger to drive cars. The other thing that's interesting to see, and the other flaw in their logic, you look at their press release, they say people 18 to 24 engage in, a lot of unsafe and ill-advised conduct. So they're not saying that they want to take the gun rights away just from the 20 and under crowd. They want to take away from 24 and under. And, if they succeed there, who's to stop them from not looking at 25? I mean, at what point would the Brady Center say, oh, this is a mature group of people who can be trusted under the Constitution? So, I think it's a very slippery slope, and their own press release shows what their real game is, which is to take as many gun rights away from as many individuals as possible.
I think you're absolutely right, and I would say now this this gets outside of the legal arena, but if you are really concerned about the maturity level of a age group, well, what you need to be concerned about then is ensuring that that age group has access to education and training. You don't want to keep them in the dark even more. You don't want to, establish a situation in which you do have a bunch of immature, ignorant 30-year-olds. You actually want to try to help people, get knowledge and education.
Exactly right, and Texas is great about that. I mean, Texas has a rigorous, licensing regime for concealed carry. You have to go and you have to take a range test and you have to take a written test. And so they're not just going to let young people run wild. They have to go through these proper procedures and training, and that's why it's been a very effective program for those who are 21 and over, and there's no reason to believe it wouldn't be just as effective for those 18, 19, and 20.
So where is this case right now, David?
Well, right now, not too much has happened, although, interestingly, the Brady Center did file an amicus brief this week, and it was really incredible. They claim that Heller means that you have a right to keep a gun in your home, but you have no right whatsoever to carry your weapon anywhere. It's as though they took a giant eraser and took the word "and bear arms," rather than reading "keep and bear," just "keep arms." And it's nonsense. Again, the plain language, it's clear. Bear, and if you look at Noah Webster's dictionary from 1828, which is what the Supreme Court often does to look at the original language and meaning of the Constitution, bear meant carry. And again, the history is crystal clear. You could carry your firearm at will. And in fact, interestingly, Cam, some states at the time of the founding required you to carry a gun, for example, to church. In Virginia, you had to carry your gun to church. So the notion that there wasn't a right to carry is frivolous, and Heller itself, made clear that there is a right to carry. But the Brady Center is continuing to peddle this, and, we hear echoes of this in Chicago. We're also challenging Chicago's ordinance. The NRA is sponsoring that suit. And, again, the anti-gunners are pretending that Heller meant, you can have one gun in your home to defend yourself, and it doesn't mean anything else, and that's just ridiculous.
That is ridiculous. I look forward to hearing them try to make that argument. Now, you said that they had submitted an amicus brief. As I understand it, they also tried to withdraw, or they had to withdraw the amicus brief?
Yeah, they did. I mean, they filed it prematurely. There was nothing else happened on that day, and so it was really pretty extraordinary. Normally, they would be coordinating with the party they're aligning with, which is the state of Texas. But, Greg Abbott, who's the Attorney General of Texas, has been a good friend of the Second Amendment, and I think the Brady Center realizes there's just not going to be a lot of coordination there, so they must have not even known what Texas was doing. So it was very bizarre and, really junior varsity.
Junior varsity. All right, David, thank you again, sir, for coming on the program. Have a great weekend. I look forward to talking to you soon.
Thanks, Cam. My pleasure. Take care.
You too. David Thompson, attorney with Cooper & Kirk.